Yes, Mr Riddle.
Thank you, Lord. So, before the short adjournment, we were looking at
You're talking even more softly.
Yeah. Oh, I'm so sorry. The
Quite apart from our old ears, you will want your remarks to be there for posterity on the live stream.
Absolutely, so that I can watch myself on YouTube. We were, just before the short adjournment, looking at what are a comparatively limited number of instances in which tribunals and courts both have jurisdiction in respect of the same cause of action. And of course, going back to the discussion this morning about Brennan and Sunderland, if the Limitation Act doesn't apply because the tribunal is not a court, it would, in my submission, be entirely unremarkable to have different limitation periods in respect of this limited number of concurrent jurisdiction cases. But even if I'm wrong about that, then I think the court has my point that Section 39 as a matter of principle doesn't restrict the alternative provision that can be made. And specifically in relation to a breach of contract, of course, in the Employment Tribunal, the breach must be outstanding on termination. And therefore the example that my Lord Justice Irwin raised of a 25 or 30-year-old breach of contract being brought in the Employment Tribunal might be thought to be practically impossible. But I did say that there are examples of where there is the same self-cause of action and different limitation periods, and that is the equal pay provisions of the Equality Act. And the court has the relevant provisions behind tab 10 of the authorities' Bible. Section 127 of the Equality Act 127 subsection 1 confers jurisdiction on an employment tribunal to determine a complaint relating to a breach of an equality clause or rule. That's how.
So sorry, where are we?
1271, my lord.
Behind tab
10.
Behind tab 10, I've only got section 123.
Yes, my lord. I think that something had a.
It's another function of my not being clerked. I think some more stuff was produced.
I see, and then
I'm afraid I just had it inserted. If you give it to me, give me a moment, I will insert it. Right, we're there. Yep, thank you.
Thank you, my lord. So at 1271, which you now have, it provides that an employment tribunal has jurisdiction to determine a complaint relating to a breach of an equality clause or rule. So it's an equal pay claim. But at 1279, it provides that nothing in this section affects such jurisdiction as the High Court, the County Court, the Court of Session, the Sheriff has in relation to an equality clause or rule. So either the civil courts or the employment tribunal has jurisdiction over an equal pay claim. Of course, Abdullah was all about a situation in which a claim was out of time in the employment tribunal, but was sought to be litigated in the county court. But
so just to spell out the history, perhaps unnecessarily, but this goes back to obviously the Equal Pay Act 1970. I can't remember exactly how that was worded. It was certainly clear from that. I'm not sure the wording was quite the same, that there was jurisdiction in both the County Court and the Industrial Tribunal, as it then was. And there wasn't any problem about having to confer a special cause of action, because what the mechanism of the Act was and still is to insert into every contract of employment an equality clause, so the claim is a contractual claim.
Yes.
Yeah. Okay. So in a sense, it was the Employment Tribunal that needed to have special jurisdiction,
Yes,
not
exactly.
the ordinary courts.
Because at that time, of course, my lord, there was no contractual jurisdiction in the Employment Tribunal. That wasn't introduced until later.
And indeed, in 1970, there wasn't even an industrial tribunal. But that's a bit of a cheat because it was the 1970 Act didn't come in until 1975
Correct.
when it was amended.
And if I recall, the tribunal.
I'm just showing off my knowledge of legal history. But the important point is that the mechanism in an equal pay claim
Yes.
is via a clause inserted by the statute into the contract. So quite like the National Minimum Wage Act.
Yes, it is quite like in that regard.
Okay.
And then you have both the tribunal and the court being given jurisdiction over it. And then at section 129, time limits are prescribed in respect of the claim before the Employment Tribunal, because it says at 1292 that proceedings on the complaint or application may not be brought in an Employment Tribunal after the end of the qualifying period. And the qualifying period is defined differently depending on the sort of case, but a standard case is the period of 6 months beginning with the last day of the employment or appointment. So it doesn't run from breach, it runs from the last day of the employment. And so different provision is made in respect of limitation for an equal pay gap. What the Equality Act goes on to do then at section 132.
Sorry, section
132, my lord. Is to deal with remedies, and at 1322, if the Court of Tribunal finds there's been a breach of the Equality Clause, it may A, make a declaration as to the rights of the parties, B, order an award by way of arrears of pay or damages in relation to the complainant. But it goes on at 3 to say the Court of Tribunal may not order a payment under subsection 2b in respect of a time before the arrears day, and the arrears day in the standard case is 6 years before the day on which the proceedings were instituted. And so I say this rhetorically: if the Limitation Act applies to an equal pay claim, you wouldn't need an arrears day, because your compensation, if Mr Brennan is right, is already backstopped by 6 years. But the fact that Parliament considered it necessary to have an arrears day is because there wouldn't otherwise be a backstop, because Parliament is presumed not to do things which are unnecessary for it to do. And that is, in my submission, a clear instance where Parliament has chosen to provide a different period of limitation in respect of the same cause of action. But the normal situation, of course, is that of a claim which can only be litigated in the Employment Tribunal, such as a deductions claim. And my Lord Justice Underhill raised with Mr Brennan this morning the question of statutory pecuniary liquidated damages claims, and we've managed to come up with two.
I didn't mean liquidated damages, I meant liquidated, but it doesn't matter.
Yes. But a redundancy payment would be an example, or a guarantee payment would be an example, claims which can only be brought in the Employment Tribunal, and in which, I say correctly, as the court observed, you can't separate out the limitation of the right and the jurisdiction of the Employment Tribunal. But the real dispute between the parties in this
Sorry, just
case,
before you go on to the real dispute, were you going to take a stab, Della? I don't want to be taken to it if there's nothing relevant in it.
I intended to take you to Abdullah a little later on, if I may.
Of course, no problem at all. No, keep going.
So what I was then going to turn on to was what I say is the real dispute, which is whether Section 9 is disapplied by Section 23 as being an alternative provision of limitation for the purposes of Section 39. The court has been taken more than once to Section 39, and you will see that Section 39 doesn't define what a period of limitation is, nor does it say that a period of limitation has to have special features in order to qualify as a period of limitation. Certainly all the commentators have understood time limits in the Employment Tribunal to be an alternative period of limitation. The court has in the bundle Chitty on contracts, Harvey on industrial relations and employment law, and McGee on limitation periods. I'll take the court only to McGee because the point is the same. The section from McGee is behind tab 39 of the authorities bundle.
I think it's behind tab 38, isn't it?
Yes, I think it may have been inverted in some copies of the bundle.
Sorry, but again, that may be because my bundle isn't up to date. Anyway, I've got it.
McGee starts off with the definition of limitation that I read out at the beginning of my submissions, that a limitation period is construed as including any provision which specifies a time limit within which legal proceedings of a particular kind must be brought. That is in Chapter 1. At Chapter 27, the authors go on to say, in addition to the Limitation Act, the Latent Damage Act of 86 and the Consumer Protection Act 87, there are a number of other statutes that impose time limits on the bringing of an action. The more important of these are dealt with in this chapter. It should be observed that Section 39 of the Limitation Act declares the general provisions of that Act to be subject to any specific provision in any other Act. Consequently, all the various provisions dealt with in this chapter take precedence over the 1980 Act in their own particular spheres of applicability. And one of those is dealt with at paragraph 27.030, the Employment Rights Act 1996. The Employment Rights Act 1996 is the statute which contains the more important of an employee's rights against an employer in respect of the contract of employment. Generally, it imposes limitation periods much shorter than those allowed by the 1980 Act. The most usual period under this Act is 3 months. And then it goes on to look at various examples of claims that might be brought in the Employment Tribunal. And so clear in my submission beyond doubt that the provisions in the Employment Rights Act at the time are regarded as limitation periods by the commentators. But in addition to that, just 2 authorities that I wanted to take the court to, if I may. One is not an employment case, one is.
Sorry, not to be taken to them, but just for my note, what were the references in Chitty and Harvey?
Yes.
The paragraph references?
Yes, just bear with me 1 moment. So in Chitty, my lord, 28020 and 28028.
Yeah.
And then in Harvey.
Well, to be fair, you probably sidelined them, I'm sure you have.
So then, my lord, I was going to come on to just a little case law. Behind tab 17, the court has the case of Airy and Airy. It's, in fact, a fatal accidents claim, not an employment claim at all.
Which tab did you say?
17, my lord.
Thank you. Yep, got it.
And the issue in Airy was whether or not Section 1 of the Law Reform Miscellaneous Provisions Act was an alternative period of limitation which disapplied the Limitation Act. The court deals with that particular point at 309. It says that the second paragraph which starts, but says the plaintiff, even if it is right to hold that subject to any provision to the contrary, in the rest of section 1, subsection 1 has the effect of preserving the same periods of limitation. the section does contain in subsection 3 a provision to the contrary so far as an action as the present one is concerned. And it says that special provision in the plaintiff's submission must be considered as exhaustive so far as an action such as this is concerned, and as ousting the application of the 6-year period prescribed by the Limitation Act. Subsection 3 of subsection 1 provides that no proceeding shall be maintainable in respect of a cause of action in tort which by virtue of section 1 has survived against the estate of a deceased person, unless the conditions in one or other of paragraphs A and B of the subsection are fulfilled. A didn't matter, but it goes on 4 lines up from the bottom. The vital provision for the purposes of this case comes in paragraph B, which in cases where the proceedings are not pending at the date of the death of the deceased imposes the twofold condition that the cause of action arose not earlier than 6 months before his death, and proceedings are taken in respect thereof not later than 6 months after his personal representative took out representation. Was that an alternative provision as to limitation, so as to oust the Limitation Act? The court thought that, as one can see immediately thereafter, that cause of action arising not earlier than 6 months before the death was not a period of limitation. But they go on to say in the next paragraph, the second branch of paragraph B, on the other hand, to our minds clearly imposes a period of limitation. It provides that the action is not to be maintainable unless proceedings are taken in respect of the cause of action in question not later than 6 months after the personal representative of the deceased tortfeasor took out representation. And then they set out the rival contentions of the parties. The plaintiff contends that this special provision as to the limitation of actions of this particular kind is exhaustive and have the effect of ousting the application of the 6-year period. On the other hand, the defendant says that this special provision is in addition to and not in substitution for the 6-year period, and this is the view it commended itself to the judge, and the court says we cannot agree. The defendant's construction involves the reading of the condition in question as requiring not simply that the proceeding should be taken not later than 6 months after the personal representative took out representation, but that the proceeding should be taken out not later than the expiration of 6 months from the taking out of representation or the expiration of 6 years from the date on which the cause of action arose, whichever is the earlier. We see no sufficient warrant for attributing this effect to section 13b if it had been intended that actions such as this should be subject not only to the special period of limitation expressly prescribed, but also to the special period, but also to an overriding limitation period of 6 years from the cause of action. Section 13b would surely have contained some reference to the letter. Prima facie, if it is enacted that a particular kind of action is only to be maintainable if brought within a specified time, that means that it is, so far as time is concerned, to be maintainable if it is brought within that specified time. With apologies for reading out quite as much as I did, I hope the court can see why I did do so, because it makes clear that if you have a self-contained code as to limitation, which makes no reference to the Limitation Act, then that self-contained code ousts the Limitation Act, because if it is otherwise, you would expect Parliament to say so. I said that I would also...
Was there no equivalent of section 39?
The
under the
equivalent is the section... Yes, it's the equivalent to section 32, my lord, and that can be seen from page 300. The relevant provisions of the Limitation Act, as then in force, are set out, and section 32 was the relevant section.
Yes, that's fine.
Shall not
So
apply
as you say, it's in the footnote.
It's
Thank you.
identical
Yep.
to what is now section 39.
Yep.
I was going to go then to one employment case, and that is the case of Wilton, which is behind tab 21. and Wilton, a decision of the EAT presided over by no less of a person than Mr Justice Mummery, as he then was. And one of the issues that arose in the Wilton case was that the tribunal regarded the 3 months for bringing a deductions claim as also being a backstop, so that an award of compensation couldn't be made more than 3 months prior to the presentation of the claim. And at page 9, and it's the last paragraph of page 9, the EAT say that it is clear from section 5(2) and 3, because this was the precursor to the Employment Rights Act, it was still a claim under the Wages Act, but the language is identical, that the tribunal cannot entertain a complaint unless it is presented within a period of 3 months, beginning, in the case of a complaint relating to a deduction with a date of payment of the wages from which the deduction is made. 5(3) deals with a complaint which is brought in respect of a series of deductions and provides that subsection 2 is read as referring to the last deduction or payment in the series.
How much more were you proposing?
Not very
okay,
much.
otherwise we would read it for ourselves.
Yes,
but carry on.
Not very much at all. It just then sets out the structure of 5(1), 5(2) and 3, which is the submission, my lord, that I made to you earlier. That 5(1), in our case 23(1), sets out the jurisdiction of the tribunal. 5(2) and 3, in our case 23(2) and 23(3), prescribe the period within which the jurisdiction must be invoked. And then it says this: if there is a series of deductions week after week or month after month, as we've got of course here, the 3-month period runs from the date of the last deduction. Nothing is said in those provisions which limits the amount that can be recovered as deductions. It then refers to 5(4), which is now section 24 in the Employment Rights Act, and then says it is clear from that provision that if the complaint is well founded, there is no limit on the amount of deductions which can be ordered to be paid by the employer to the worker. And the mistake that had been made there was to take the time limit of 3 months as determinative of the amount of compensation which could be paid. So, although in the EAT and not this court, it is authority for the general, it's a specific example of the general proposition that if you have a self-contained code as to limitation, which doesn't refer to the Limitation Act in any way, then it becomes the limitation code that applies. And therefore here we say time starts with the deduction in the starts to run with the last in the series of deductions and ends 3 months later. That's the limitation period, that's the time limit. There is no double limitation period, which says you've got to bring it within 3 months, but only in respect of deductions which arise in the last 6 years. Mr Brennan suggests that this makes life very uncertain. I think he described it as a shifting cab. But with respect, I don't see why that should be. If, hypothetically, my employer makes a deduction from my wages on the 1st of January, I must bring a claim by the 31st of March. Only if my employer makes another deduction from my wages in that 3-month period am I permitted to run time from the second deduction rather than the first, because that's what the Bear Scotland case says. Certainty is provided by the fact that a series requires both a sufficient factual and temporal link for there to be a series. And unless the court particularly wants me to do so, I'll simply give you the paragraph references in Bear Scotland. It's paragraph 79 to 81, where Mr Justice Langstaff says that you lose your temporal link once a period of 3 months expires between deductions. So, frankly, in any given 3-month period, you know exactly where you are. If only one deduction is made in that 3-month period, you bring your claim within 3 months of that deduction. Only if there is more than one deduction in that 3-month period do you have recourse to the series. And of course, there's never been any dispute in this case that we have a series, because week in, week out, month in, month out, when Mr Coletta was working, he was underpaid because he received nothing in respect
Classically,
to those
I
hours.
think fancy examples, but classically employees are either paid every week or every month.
Yes.
And so if there is some systematic reason why they're underpaying, it'll happen
Precisely.
it'll happen throughout.
Yes.
Yep.
Precisely so. Mr Brennan also says, well, it's all very unfair because he makes reference to the record-keeping obligations that are imposed by the National Minimum Wage Act, and says you only have to keep records for 3 years, and then he also refers to the burden of proof. But of course, what applies in this case must apply to all deductions claims, and there aren't any record-keeping obligations on employers as to whether or not you pay your bonuses every month, or basic pay, or overtime. And so record-keeping obligations can't possibly be the thing that drives the question of the recoverability of compensation. Equally, in the normal case, the burden of proof is on the employee or the worker throughout to prove that there was a sum that was payable and has been deducted from the wages. And even in a national minimum wage claim, where there is a burden on the employer to establish that he has paid the national minimum wage, the burden is on the employee, of course, to prove the series. And therefore, the claimant is the person, frankly, who runs the risk if he brings a claim very far down the line of an employment tribunal saying, well, I'm sorry, there's not a sufficient factual connection here, there's not a sufficient temporal connection here. But what, of course, is important is what the provision says. And the restrictions that Mr Brennan seeks to put on what is and is not a limitation provision. He says, Section 23 can't be a limitation period because it doesn't bar the remedy. It can't be because you have to have a period which starts with the accrual of cause of action and which ends after a defined period of years. But, and I'll try and do this as quickly as I can, if you actually look at various provisions of the Limitation Act, they are utterly inconsistent with those two propositions as being necessary criteria for a limitation period. To start
Sorry,
off,
I didn't note what you said the two necessary propositions were.
so the two propositions, one has said a limitation period has to bar the remedy. It can only bar the remedy, and if it doesn't...
As to what, sorry?
It has to bar the remedy and
Bar the
only
remedy.
the remedy.
Yeah.
And secondly, it has to bar the remedy by reference to a defined period of time which starts with the accrual of cause of action and ends after a defined period of years. Those are the features which are said to exist in a limitation period, and if it doesn't pass those tests, it's not a limitation period. So to start off with the, it can't be a limitation period unless it only bars the remedy. If I could ask the court, please, to go to tab 5, and behind tab 5 you will find the Limitation Act. Because first of all, there are instances in the Limitation Act where the passing of limitation bars the right as well as the remedy in exactly the same way as happens in the Employment Tribunal. And Ms Jones rightly reminds me that if you don't have your new version of the Limitation Act...
I'm ahead of you. I worked out that's what you were about to do.
I'm very grateful because the relevant passages are sidelined. So I'll deal with it relatively swiftly. At section 3.2, time limit in case of successive conversions and extinction of title of owner of converted goods. So 3.2, where a cause of action has accrued, period prescribed for bringing that action has expired, the title of that person to the chattel shall be extinguished. So that's an example of a limitation period which bars the right and the remedy once time limit has expired. And another example is section 17 of the Limitation Act. This deals with extinction of title to land. At the expiration of the period prescribed by this Act, for any person to bring an action to recover land, including a redemption action, the title of that person to the land shall be extinguished. So, unless Mr Brennan is saying that those are not limitation periods, even though they're in the Limitation Act, they are squarely against the proposition that a limitation period can only bar the remedy. As to the second proposition, there are examples in the Limitation Act where it is not the accrual of the cause of action which causes time to start to run. And in particular, section 11, which is the special time limit in respect of personal injuries. So where you are bringing a claim in respect of personal injury, as I'm sure the court is very familiar with, subsection 4 says the period applicable is 3 years from A, the date on which the cause of action accrued, or B, the date of knowledge, if later, of the person injured. And so not only does time not run from the accrual of the cause of action, but you won't know when it starts to run until the court has made a determination of the state of the person's knowledge. And section 14 of the Limitation Act deals with the various matters that the court needs to take into account in looking at when somebody has acquired knowledge. And in particular, at section 14.3, there is the concept of deemed knowledge.
Yeah.
It's not just what you actually know, but what you should know.
You say this is pretty familiar to me, and I suspect even more familiar to those on the other side.
Absolutely so. But the simple point is this: you simply can't say when the cause of action accrues. It might accrue on the when it might time limit might start when the cause of action accrues, might not, but it doesn't prevent it from being a limitation period. It is the simple point. And equally, if one looks at the end of the period, there are instances in the Limitation Act where time does not expire on a fixed date either. In the sense of a fixed date referable to the accrual of the cause of action, and that's section 14b, where you are not concerned with a personal injury claim. An action for damages for negligence other than one to which section 11 of this Act applies shall not be brought after the expiration of 15 years from the date, or, if more than one, from the last of the dates on which there occurred any act or omission. So, again, this is a series case. You can have a series of wrongs perpetrated, torts committed, and time runs from the last in the series, not the accrual of each cause of action. And again, that is not precluded from being a limitation period. There are also, of course, examples in the Limitation Act of discretionary extensions of time being available, section 32A and section 33. None of this prevents it from being a limitation period. And so the rather forensic exercise of going through the Limitation Act proves, in my summation, why what Mr Brennan says is a limitation period isn't, because the Limitation Act itself contains examples of limitation periods which simply do not meet his test. Then two more case references. First of all, the case of Stringer, which you will find behind tab 29 of your authorities bundle.
Yes, when I first referred to that in argument, I'd forgotten it was in the bundle, but yeah, thank you.
So it's the judgment of Lord Neuberger, which starts at 1006, where he sets out at paragraph 66 the issue that concerned the court on that occasion, which was whether you could bring a holiday pay claim under section 23 of the Employment Rights Act, notwithstanding you could also bring it as a regulation 30 claim.
Perhaps we can just spell that out.
Of course.
I had looked at it just earlier. The right is created by the working time regulations.
Yes.
The working time regulations has a series of provisions about enforcement in just the standard thing. Claim can be brought, but claim can be brought in the Employment Tribunal, must be brought within 3 months, nothing about any series, but so absolutely standard. And that's what you might call the remedy that on the face of it goes with.
Yes.
And in the Court of Appeal, where I appeared, I was able to persuade them that meant that was the only that was the only way in which you could enforce it. But because they wanted to take advantage of the series of deductions point, the claimants said, no, we'd rather bring a claim, and we have brought the claim under the Employment Rights Act, and that's a parallel machinery, and it's more favourable to us, so we'll use it.
Yes.
Have I got that right?
Yes, precisely so.
And the House of Lords agreed?
Yes, they agreed. But what one sees is them referring to section 23 as a limitation period. And at paragraph 67, if the answer is the negative, you can only bring a claim under regulation 30, then the limitation period is that set out in regulation 30. But if the answer is in the affirmative, you can do both. And the claim could alternatively be brought under section 23. The regime is more generous. While section 23 2A has a similar 3-month limitation period, says Lord Neuberger, section 23.3 provides that where there has been a series of deductions or payments, the period starts from the last deduction or payment in the series. So that's him using limitation period to describe the time limit in section 23. And also at 1008 letter H, where he is dealing with submissions relating to the principle of equivalence. At paragraph 80, he says this issue requires one to address two points, namely difference in limitation periods and similarity of claims. In relation to contractual holiday pay and all other sums covered by section 27.1, an employee can rely on section 23.3 of the Employment Rights Act. This effectively extends the start of the 3-month limitation period in any case where the deduction was one of a series of deductions until the date of the last deduction of the series. So it, in my submission, makes nothing of this purported distinction that was made in the concession of the EAT. It makes clear that it's a limitation period, whether one is looking at a single deduction or a series. Then Abdullah, very briefly, if I may. Abdullah at paragraph 42. Forgive me, my lady.
It's the next case. Yep.
So Abdullah was an equal pay claim, and it was concerned with whether or not it's possible to go in the county court when one was out of time in the Employment Tribunal. So the judgment of Lord Sumption is a judgment in the minority, but this passage that I'm about to read is not him disagreeing with the majority in respect of the disposal of the case. What he deals with at paragraph 42 is a second of 2 points that he's making about the special, what he put terms, the special limitation provisions in the Equal Pay Act, which have made their way over into the Equality Act. He says the second introductory point is that dismissal of a claim on the ground that it is time-barred is a disposal of the claim. Limitation is a defence. A dismissal on that ground is a judicial decision giving effect to that defence. It was submitted to us that the introductory words of section 2.4 mean that the provision is a limitation on the Employment Tribunal's jurisdiction. There is authority that provisions in this form or substantially similar do go to jurisdiction, and he cites Radakovits in this court. He then goes on to say, I am by no means convinced that this is correct, but it is unnecessary to decide the point because section 2.4 plainly gives rise to a defence in proceedings before an employment tribunal, even if it also operates as a limitation on the tribunal's jurisdiction. The words cannot mean that the tribunal is disabled from determining whether the claim is time-barred. The only consequence of treating section 2.4 as going to jurisdiction is therefore that the defence cannot effectually be waived. So what Lord Sumption is saying is there's no such thing as a jurisdictional restriction, which is not a limitation period. The time limit for bringing a claim in the Employment Tribunal may go to the jurisdiction of the tribunal, but it is also a time limit. It's just that because it goes to the jurisdiction of the tribunal, then it cannot be waived at the option of the magnanimous employer who decides not to take a time point. Although rather like Mr Brennan, I think it's right to say that parties are always very astute to look for limitation points.
I think let's, for goodness sake, not go there. But I think I wasn't aware of those doubts. But from time to time, I think other courts, including me, have said, I don't really think that it's going to jurisdiction.
Yes.
But it does. But your point is it doesn't matter.
It doesn't matter because it does. It may be that it does two things, but it still does two things, not just one. It may be a jurisdictional restriction, but it is also a limitation period. And therefore this idea of there being two separate things and that section 23 is not capable of being a limitation period, I say it is put it is wrong, and that is put beyond doubt by that passage from Lord Sumption. But also, and of course council always do this, is to say, well, think of the consequences if the other side, think of the consequences, my lord, if the other side is right. If section 23 is not a limitation period using Mr Brennan's criteria, no time limit in the employment tribunals is capable of being a limitation period because, says Radakovits, they're all time limits which bar a claim and not a remedy. So there are apparently no limitation periods in the employment tribunal at all. Which is an extraordinary proposition, and not one that I've ever heard suggested by anybody else. And there is a further problem in discrimination claims, because one of Mr Brennan's criteria is that it can only be a limitation period if time starts to run when the cause of action accrues, when what you're complaining about actually occurs. But of course, in a discrimination claim, you are permitted expressly to aggregate everything that you're complaining about together and bring a claim within 3 months of the date of the last of the things you're complaining about, provided you can show that it's a continuing act, which conceptually is the same thing as a series of deductions. And so, thinking it through a little further, if section 123 of the Equality Act is not a limitation period, you can't bring a claim in respect of discrimination which occurred more than 6 years before you brought your claim. You might think that would have occurred to somebody before now, if that was true, but it certainly raises issues, I put it no higher than that, about whether that gives proper effect to EU-derived legislation. But if, of course, you're seeking personal injury damages, if you're seeking damages for personal injury caused by discrimination, you're even worse off because you can't bring a claim more than 3 years after what you're complaining about. And that raises a whole host of issues, Does personal injury include injury to feelings or not? Are you able to make an application to Section 11(4) for an extension of time based on delayed knowledge? Does the tribunal have jurisdiction to consider that? The tribunal doesn't have jurisdiction over the provisions of the Limitation Act. If it does have jurisdiction, how? If not, how do you decide the Section 11(4) point? Or are you not able to make the application at all? Why, when you can make it if you're bringing a personal injury claim in the civil courts? And that, my lord, then I think brings the Brennan point that we were discussing earlier back into focus. Because one of the things that you were concerned with in Brennan was the absence of any reference to the Civil Liability Contribution Act and the absence of jurisdiction for the Employment Tribunal to operate its provisions. So it would appear equally here, the Employment Tribunal doesn't have jurisdiction to operate the provisions of the Limitation Act, and therefore you are almost driven to the conclusion that you cannot seek to defer the beginning of the running of time against you when you are seeking personal injury damages in respect of a tort claim, even though it's exactly the same claim as you would bring in the civil court, save that you're now concerned with discrimination rather than negligence or any of the other torts.
Yes, and just to spell that out, it is well established, though at first it comes as a surprise to people, that you can bring a personal injury claim. Obviously it will be psychiatric damage of some sort, but nevertheless a personal injury claim as part of a race discrimination claim. And you say that how's that going to work?
How's that work?
Yeah, in the if the Limitation Act applies. Yeah.
If exactly, 1, 2, 3 is not a time limit, Limitation Act applies, how does it work? How do you deal with the 11(4) problem?
Yeah. Okay.
And it's when you get in, you come up against a problem like that and you have no answer, is why I say you have started off down the wrong path in the first place. There is a simple answer to this. It's the one that's identified by Lord Sumption in his judgment in Abdullah. An Employment Tribunal time limit is a limitation period, and therefore it disapplies the Limitation Act altogether. I won't take the court to it now, but there is also what I've termed in my skeleton argument, the holiday pay problem. If Mr Brennan is right, the court has King behind tab 34 and paragraphs 24 and 63 to 65. If there is a backstop, then you can't bring a claim in respect of consecutive failures to provide for the right to paid annual leave. It's a different species of the same problem that we've just been looking at by reference to the Equality Act. So, unless I can assist any further on that, I was just going to turn briefly onto the application.
Thank you. You've been of great assistance. Thank you. Those are very helpful submissions, and we don't need to hear you on the extension point.
Thank you.
My Lord, I have a small number of short observations to make on my learned friend's submissions. First, this point about whether a deductions claim under Part 2 is a freestanding head of liability. My submission was and remains that one has to identify the underlying legal relationship which gives rise to the right to the money. Otherwise, you cannot establish a right to payment. And Part 2 of the Employment Rights Act, in my submission, is not a cause of action, because there is no right to payment without identifying the contract which underpins the non-payment. And the discussion, particularly during my learned friend's submissions, confused in my submission the cause of action with the remedy. And that, I submit, is the answer to the point which my Lord Justice Irwin raised with my learned friend. Why should Parliament, as I think his Lordship put it, intend to give you 20 or 30 years if you make your claim within 3 months? But if you take 12 weeks and 4 days to put your claim in, then suddenly Parliament has limited you to 6 years. That is, on any view of my submission, an odd result. And it is an odd result which is avoided if one gets the nomenclature right and identifies that Part 2 of the Employment Rights Act provides a remedy for non-payment by the employer of sums which are due under contract. At all times, an employee who is claiming wrongful deduction has got to establish, either by leading his own evidence or by reliance on a statutorily reversed burden of proof, that he has been underpaid, and that underpayment relates to his contract. So it confuses the issue and leads, in my submission, to the wrong answer to say that he has a freestanding cause of action under Part 2. Part 2 gives him a remedy. It gives him a forum where, at least in conventional legal theory, he can enforce his rights quickly and cheaply with a minimum of legal representation and so on. But it doesn't give him a new cause of action. He's still entitled in contract to a debt, and it is that contract which is what entitles him to payment if the Employment Tribunal rules in his favour. And therefore there is no peculiar outcome of the type explored in Lord Justice Irwin's question, because the right is statute barred at 6 years. If the employee gets into the tribunal within 3 months, he can enforce his claim back for 6 years. If he misses it, he can still enforce his claim back for 6 years, but in a forum which has a less abbreviated period during which he needs to bring his claim. My learned friend, I'll move on to a separate point of reply. My learned friend referred the tribunal to airy and airy. Don't turn it up. It's tab 77. Tab 17. That's an example of a case of the types which I, if I can put it like this, warned against early in my submissions, where there is a freestanding statutory regime. The claimant in airy and airy was taking advantage of the statutory abolition of the rule that the action dies with the victim. Taking advantage of that rule, he or she was able to bring the claim in accordance with the restrictions and benefits of that rule, so that the fact that the wrongful act had occurred more than 6 years before did not debar the claimant, because the claim was being brought in the context of a self-contained statutory regime. It tells you nothing about a limitation period embedded within Part 2. A similar point can be made in the same way in respect of the equal pay provisions. And I've already made the observation, which I won't repeat at length, that of course where there is a European element particularly, but a self-contained legal regime anyway, there are all sorts of other factors involved, particularly as we saw in that quotation we looked at from Lord Newburger's speech, equivalence as being a relevant question in Stringer for importing Part 2 into the enforcement regime. A reference was made to Bear Scotland and to the question of a series. May I just draw the attention of the tribunal, of the court, to a fact in relation to Bear Scotland, so that you know it exists if the case seems of great significance. It's behind tab 32.
This is the last word on what a series of deductions means.
No, my point was to tell you that it's not the last word.
Oh, right.
And that's why I wanted to turn it up. So, Mr. Justice Langstaff, at paragraph 79, talks about what is a series of deductions, and buried, I think it's in 80 or 81, he says, well, if there's a gap of 3 months, that stops it being a series.
Yes, that's...
With respect to his lordship, he may or may not be right about that. I accept that whether something is a series is a question of fact. However, that point, about that 3-month gap, has just recently been doubted in the Court of Appeal in Northern Ireland. The reference...
where is the... 79, where's the bit about the 3-month gap being...
81.
81.
And by reference to the materially equivalent but differently named legislation in Northern Ireland.
What's the reference to the case in which
the case is called Chief Constable of Northern Ireland against Agnew and others.
The second name, please, Constable?
Agnew, A-G-N-E-W. The reference is 2019 NICA 32. And the court visited that decision on us on the 17th of June. It's not in the bundle. I just want your lordships to be aware of it.
It's very up to date of you. But we would expect no less.
My learned friend, I don't think it's necessary to turn these up, took more than I had said from what is a limitation period. My observation in my skeleton argument was that a limitation period runs typically from the date of accrual of the cause of action. Of course, I recognise that there are other occurrences which can be the beginning of the cause of action, of the limitation period. For example, date of knowledge, date of constructive knowledge, and so on. And I wasn't making any submission in ignorance or disregard of those obvious points. She pointed to a couple of provisions, and on reflection, I think I should pick those up, if I may. Limitation Act is behind tab 5. This was in support of my learned friend's submission that a limitation period doesn't just bar the remedy. Forgive me, a limitation, expiry of a period of limitation doesn't just bar the remedy. And she made a couple of bold points about that, which I'd like with respect to correct. The first arose from her reference to Section 3 of the Act. She says, well, look at Section 3, subsection 2, where a cause of action has accrued and the period prescribed for bringing the action has expired. Title to a chattel shall be extinguished. And she says, well, that's a limitation provision. No, it isn't. The limitation provision for conversion of chattels is in one or both of Section 2, cause of action founded on tort, the tort of conversion, or Section 3.1, successive conversions. The relevance of section 3.2 is not that it's some other special occurrence of the start of a period of limitation, it's that it extinguishes a proprietary claim, because otherwise you would get the situation where somebody who is barred by limitation from recovering property, such as a chattel, is nonetheless able to engage in self-help or sale or other means of taking advantage of his proprietary ownership.
So it's a consequence of the expiry limitation.
Yes. It's working through what you've been barred because you didn't bring your claim within the limitation period, and so there has to be specific statutory provision extinguishing your title to the chattel. Then there is a precisely equivalent provision in respect of recovery land. That, I think, is section 17. Yes, that's extinction of title to land after expiration of time limit. I won't read it. My learned friend says, well, unless Mr. Brennan is saying that's not a limitation period, then there we are. Well, I am saying exactly that. The time limit for an action to recover land is not in section 17, which is extinction of title. It's in section 15. That's where you find the 12-year period of limitation in land. And section 17 is again a working through of the consequence of becoming statute barred in relation to title to land. The significance of those points is that they do not undermine, in the way that my learned friend submitted, my basic proposition that a limitation period, relevantly in contract, starts to run from accrual of the cause of action and expires 6 years later. And this case only begins to look difficult if one gets the nomenclature wrong and fails to recognise that a claim under Part 2 provides the worker with an additional remedy for enforcing his entitlement to his pay, rather than giving him a whole new cause of action subject to its own limitation. It's just telling the tribunal, which of course is a creature of statute and only has the jurisdiction which statute gives it, you, the tribunal, can enforce this individual's contractual rights to his pay, which has been wrongfully kept from him by his employer, in these circumstances. And it's that error of nomenclature which makes this case look difficult. Once that's corrected, one can see that the oddness which can be seen in the circumstances described by Lord Justice Irwin, that you could start your claim after 3 months less a day and go back 30 years, or come along 3 months plus a day and be told, no, you can't, and now you're limited to 6 years. That's a very odd result, if correct. In my submission, it's not correct because it rests on a misdescription or a misunderstanding of the function of Part 2 of the Employment Rights Act. And finally, almost trivially, my learned friend likes, in her written submissions and also orally, to describe the claim in relation to the wrongful deduction from wages, as I characterise it, as a claim for breach of contract. One ought to try to be a bit purist about it. It's a claim for a debt. It is, I suppose, a breach of contract not to pay a debt, but it is not a claim for damages for breach. You can bring claims for damages for breach of contract in the circumstances addressed in the extension of jurisdiction order. That, I think, unless I can assist the court, that is exhausts my points of reply.
We'll just rise for a moment.
I'm quite surprised. What stage of your career are you at?
I'm just starting
In October 20. Maybe.
I'm going to my Justice Appeal Tribunal.
Done very well to get a JA post.
No, very lucky. It's all very interesting.
I'm sure it wasn't luck. How long have you been doing it?
It's the legal year, so I started in October.
Right, so this will be very, very close to the end of your... And what are you going to do in the intervening?
So it's a trade back on an international, so I'm going to go into the European Court. And then
Goodness me. You've got a lot of strings to your bow with stars on your breast.
you have to sort of the offering open path.
You've done really well to get you've reached a big step in a long, literally profitable career ahead, I'm sure.
I hope it's fruitful in the end.
Are you from Manchester?
Yeah, I grew up in Leeds.
It's good, well done, isn't it?
It's
You spent all your time with Steve Irwin.
we're all the same. Done justice. Where you go back.
Yeah, but I don't know whether they sort of swap you over.
I think there is room to move a little bit, but gently.
Probably being broadcast. I haven't said anything in Britain.
Yeah, we'll still be.
Are we? Oh, okay.
Yes, that's why
Thank you. Yes, the big red line. Bit of a giveaway.
On the day, probably, normally wait 6 weeks and then
The last time I was here in this court as live stream, I think we were one of the first cases to be live streamed. And at one point, not word for line, a tourist just comes in through the door, walks everywhere, and then just walks over and starts taking the books off the shelf in mid-flow of
During
the
the case?
appeal. It was just, and it was Justice Underhill and the charity. And then just ambles back out again, happy as Larry.
How extraordinary.
It was utterly extraordinary.
Wow.
We were embroiled deep in indirect discrimination and equal pay at that point. Bit of like relief.
Someone had probably told him it's a public court. You can
Well,
go
exactly.
in.
Yeah, it doesn't quite mean go in and have a look at what books they've got on the
Go in and
shelf.
have a picnic.
Court rise.
clearly not going to be in a position to give you reasoned judgments, but it did seem to us that, given that the vacation is upon us, that we ought, if we felt able to do so, to tell you our definitive decision, and we are able to. The appeal will be dismissed. Reasons to follow as soon as we can do it, but as I say, the vacation creates something of an obstacle. You will already, of course, have inferred from the fact that Ms Criddle wasn't called on, that permission to appeal will also be refused on the liability issue. Sorry, the extension, and therefore inevitably the permission to appeal. Now, it did occur to us what consequential matters there might be that we could usefully deal with today, because in principle an order will now be drawn. Costs you've agreed, so that's straightforward. Do the terms of the stay that you told us about involve the court in any way?
They should. May I explain why?
Yes.
Judge Eadie, I think, granted the stay, and I can't now remember, and it doesn't matter whether that was the terms were by agreement. But what has happened is that a sum of the order of £54,000, which would now be payable to Mr Coletta, is in the hands of his solicitors. There is a potential problem which I invite the court's assistance in resolving, which is this. That is a gross sum. It is arrears of remuneration,
Yes.
and it is therefore subject to PAYE.
Yes.
It can't properly, or even lawfully, be paid directly by Mr Coletta's solicitors to him without PAYE being operated. It's not their job to operate PAYE, nor their responsibility to calculate it. There are, I suppose, several ways in which it could be dealt with. One way in which it could be dealt with is for the entire sum to be repaid to the company's solicitors, so that PAYE can be operated and the balance paid as arrears of net remuneration to Mr Coletta. PAYE has to be operated by the technical term employer, and the employer is the person who pays the earnings. So it can't just be left on the basis Mr Coletta's solicitors can just pay.
I see that. I'm wondering whether, though the order won't be drawn today, we'd ask counsel to submit. I mean, if there wasn't this complication, frankly, wouldn't be any need for a draft order. It would simply be appealed, dismissed, no orders to costs. But if the two, I haven't even seen Judge Eadie's order, but if that means that we have got to make an order, I would be surprised if the two of you couldn't suggest a sensible and hopefully straightforward mechanism that got over these difficulties, which would then be reflected in the terms of an agreed order. Payment out, I don't know, I'm not going to suggest what the mechanism is, so I haven't thought about it. But that's frankly something I would have thought that the two of you could do. I won't even say overnight. Monday morning is fine.
I think we will be able to do it. I just wanted to flag it now so that we won't put in the position of it being suggested that immediately the appeal is dismissed, the money must all be paid gross to Mr Coletta, because that would cause...
No, well, I see that. Have we actually got Judge Eadie's order in the bundle? I hadn't noticed it. And I don't really want to look at it now, but I just thought, well, if we had it, I would look at it now, but it's not essential. I just wanted to see if there are any problems that we could spot that unlikely you haven't.
Because what happened was that when the appeal was allowed before the Employment Appeal Tribunal, because it was Mr Coletta's appeal below, then the sum had been agreed, it was ordered to be paid, and after the order had been agreed between the parties, there was an application for a stay of execution of the order by the appellant, and that prompted Mr Coletta's solicitors to say, well, we are willing to hold the money
Yeah,
in our
I
client
do, yeah.
account.
But the bottom line is there an order?
No, there is, well, if you just bear with me a moment, my lord.
If there isn't an order and the parties have agreed something, then prima facie, my lord and my lady may teach differently. You've simply got to give effect to the terms of the agreement. But if there's been an order, we've got to do something about it.
The other point is this. I'm just looking at the witness statement in the supplementary bundle of Mr Coletta, and it was the one to which the court's attention was drawn, where he sets out his debts. He seems to have received the balance on this sum, gross, and he has been in correspondence with HMRC as to the deduction. So why now is this coming in at this point?
That relates to the first 39,000.
Yes, it does, that's right.
Not to the 54,000.
Yes, that's right.
The 39,000 should never have been paid to him without deduction of PAYE, and that was a mistake.
Right.
It seems to have been a mistake on the basis, well, Mr Coletta will deal with his own tax affairs, but the obligation is unquestionably on the employer to deduct, and so we don't want to repeat that mistake.
Have you got to the bottom of it, Mr. Irwin?
The order, my lord, is that of page 32 of the bundle.
Of the core bundle?
Yes, of the core bundle on Ramsey. This is the only court order that there is. It is the order by consent for the appeal to be allowed, the deduction.
I see. So, in
and
fact,
then for payment.
the arrangements that we were being told about are made in correspondence. I mean, sure, they form
So
a
they-
binding contract and
so
all
our-
that, but we
yes.
don't, I'm not sure we have locus to make some special order about what should happen.
As I say, what happened after this order was drawn up was there was an application for a stay of execution, and we said we'll put it into the client account, and then there is somewhere, although we don't have it in the bundle, a rejection of the application by the Employment Appeal Tribunal, amongst other reasons, because there'd been an agreement by us.
Well, all that is fine, but I don't, again, unless my lord and my lady say anything different, or either of you say anything different, I don't see how we can make some helpful observations. I'm very happy to do that. I don't think how we can actually, we haven't really locus to set up a mechanism or endorse a mechanism.
Yes.
There is an order for the money to be paid. If we've dismissed the appeal, then it
money
must be
has to
paid.
Yeah. Yes.
Of course, it must be paid lawfully, and I don't suppose you disagree with this. The solicitors will have to get together
I think they will. I mean,
and work out a mechanism which makes sure that the respondents aren't in breach of their duty to HMRC,
of course.
but they agree about what amount should be paid to HMRC and what not,
And who does it?
and who does it.
Yes.
In a perfect world, you get HMRC to agree as well, so they didn't come back. If that wasn't possible,
Yes.
there'd have to be some sort of mechanism to make sure that if they paid the wrong amount, either by too much or too little,
Yes.
the difference was sorted out. These things happen quite often in employment situations, and with a bit of guidance from such eminent counsel, I can't believe it can't be a way can't be found. But it doesn't sound to me at the moment so it goes in our order.
No, I suspect not. Rod. The only other matter that Mr. Jones reminds me of is the question of interest, because there is judgment interest due on the sum, and it's been held in the client account, and therefore that is owed to Mr. Coletta too.
Well, I think the same applies. The order of Judge Eadie is that a certain sum of money be paid within
Yes.
28 days. The parties have agreed not to do that on certain terms.
Yes.
Perhaps those terms will have specified something about interest. If they didn't, I'm sure there will be an implication of some sort, but I'm not going to venture what it would be, and that you'll just have to sort that out.
Yes.
In principle, of course, he must have interest, but at what rate? I'm not going to say.
But, and on what amount? Because if there was a legal obligation to pay to HMRC,
Yes.
then interest calculated on the whole amount would clearly
No,
be...
I take that point, my lord. He can't. If a proportion of that money was never lawfully his because it belonged to the revenue, then of course he can't have interest
It
in
should
that.
only be on the net amount. And I can see all sorts of obligations which will not, I imagine, prevent paying out the lion's share. It may be, if there needs to be sorted out, you may have to hold a precautionary sum back until a sensible mechanism has been devised. Yes, I don't know whether the revenue will be after any more for penalties in these circumstances, but or for statutory interest in any event.
I suspect, my lord, you're right to say that it is a matter for the parties to resolve, and only if the parties can't resolve it will we trouble you.
Well, no, what I was putting is I don't think you can trouble us.
Yes, because it's
Because
an order. Yes.
I don't see how it falls within our jurisdiction. You think it might? My lord thinks I'm being too pernickety.
No, I don't think you are. I think what they could do is come back to the template.
Yes.
Yeah.
It's possible. Don't quote us on this. If you could go back to anyone, it's the EAT,
Yes.
because it relates to her order. Though even then, it doesn't strictly relate to her order. Because her order was simply pay the money.
Yes.
But one way or another, she might well have jurisdiction. I haven't worked that out, but we haven't.
Yes. Thank you.
Well, I think that's everything. Thank you both. The only thing I can say is that if you'd been here 2 days ago, there would be no air conditioning in this court, and you would have been less comfortable than I hope you have been, at least physically. But thank you. It's been very well argued on both sides.
You need for tax, and we'll give you tax.
Yes, I don't think you want to go down the route of either Paris Smith